All right. 37. Within these few days, while we were sitting at the tribunal of our friend Quintus Pompeius, the city praetor, did not a man who is ranked among the eloquent pray that the benefit of the ancient and unusual expectation of which sum there is time for payment might be allowed to a party from whom a sum of money was demanded, an expectation which he did not understand to be made for the benefit of the creditor, so that if the defendant had proved to the judge that the action was brought for the money before it became due, the plaintiff, on bringing a fresh action, would have precluded by the exception that the matter had before come into judgment. What more disgraceful, therefore, can possibly be said or done than that he who has assumed the character of an advocate, ostensibly to defend the causes and interests of his friends, to assist the distressed, to relieve such as are sick at heart, and to cheer the afflicted, should so err in the slightest and most trivial matters as to seem an object of pity to some and of ridicule to others. I consider my relation, Publius Crassus, him who from his wealth had the surname Dives, to have been in many other respects a man of taste and elegance, but especially worthy of praise and commendation on this account, that as he was the brother of Publius Scovola, he was accustomed to observe to him that neither would he have satisfied the claims of the civil law if he had not added the power of speaking, which his sons here, who was my colleague in the consulate, has fully attained. Nor had he himself begun to practice and plead the causes of his friends before he had gained a knowledge of the civil law. What sort of character was the illustrious Marcus Cato? Was he not possessed of as great a share of eloquence as those times and that age would admit in the city, and at the same time the most learned of all men in the civil law? I have been speaking for some time the more timidly on this point, because there is with us a man eminent in speaking, whom I admire as an orator beyond all others, but who has ever held the civil law in contempt. But as you desire to learn my sentiments and opinions, I will conceal nothing from you, but as far as I am able, will communicate to you my thoughts upon every subject. What is that, 38? Yeah. The almost incredible, unparalleled, and divine power of genius in Antonius appears to me, although wanting in legal knowledge, to be able easily to sustain and defend itself with the aid of other weapons of reason. Let him therefore be an exception. But I shall not hesitate to condemn others by my sentence of want of industry in the first place, and of want of modesty in the next. For to flutter about the forum, to loiter in courts of justice and at the tribunals of the praetors, to undertake private suits in matters of the greatest concern, in which the question is often not about fact but about equity and law, to swagger in causes heard before the centrum in which the laws of prescriptive rights, of guardianship, of kindred, of agnation, of alluvans, circumluvian, I can't say these words, alluvians, circumluvians, of bonds, of transferring property, of party walls, lights, stilicidia, of wills transgressed or established, and innumerable other matters are debated, when a man is utterly ignorant what is properly his own and what his neighbor's. Why any person is considered a citizen or a foreigner, a slave or a free man, is a proof of extraordinary impudence. It is ridiculous arrogance for a man to confess himself unskillful in navigating smaller vessels, and yet say that he has learned to pilot galleys with 5 banks of oars, or even larger ships. You who are deceived by a quibble of your adversary in a private company, you who set your skull to a deed for your client, in which that is written by which he is overreached, can I think that any cause of greater consequence ought to be entrusted to you? Sooner assuredly shall he who oversets a two-oared boat in the harbor steer the vessel of the Argonauts in the Euxine Sea. But what if the causes are not trivial, but often of utmost importance, in which disputes arise concerning points of civil law? What front must the advocate have who dares to appear in causes of such a nature without any knowledge of the law? What cause, for instance, could be of more consequence than that of the soldier, of whose death a false report having been brought home from the army, and his father, through giving credit in that report, having altered his will and appointed another person whom he thought proper to be his heir, and having then died himself, the affair, when the soldier returned home and instituted a suit for his paternal inheritance, came on to be heard before the centrumviri. The point assuredly in that case was a question of civil law, whether a son could be disinherited of his father's possessions, whom the father neither appointed his heir by will or disinherited by name.